Welcome back to the Deep Dive. Today we are undertaking a pretty critical mission, actually, clarifying the essential and, let's be honest, often misunderstood role of the real estate attorney. This isn't just theory, it's really about practical risk management. I mean, if you're preparing for your first closing, or maybe you're a seasoned investor looking at something more complex like seller financing or distressed assets,
Right.
you've definitely asked this question. Okay, I already have a fantastic real estate agent handling the deal, and there's a title company providing insurance, so why on earth should I spend thousands more on a lawyer?
And that question, it's the perfect place to start this deep dive because it gets right to the core difference between just a business transaction and, well, a legally secure asset transfer.
Right.
Your real estate agent, they're selling their time, their market knowledge to get a sale done. They're focused on price, negotiation, the business terms, basically.
Makes
And the title company, at least in most states, their job is mainly executing the paperwork and, crucially, providing an insurance policy against a title defect they might happen to miss.
right, the insurance part. But the attorney, where do they fit in differently?
The attorney. They're selling pure legal strategy and, really, risk mitigation. Their number one function is to provide counsel, guidance, wisdom, and strategy. Think of it as the legal foundation ensuring everything holds up if challenged, in court.
Okay.
If you look at the source materials we reviewed, they describe the attorney's role as providing that essential legal labor, but also contacts, connections, leverage,
Huh.
all part of what they call the investor's work network.
That work network term.
No.
It keeps popping up in the material. It sounds like more than just, a Rolodex. Let's define that for the listener.
Good idea.
It seems to be this interconnected group of experts, ideally best in class, who provide advice, intelligence, knowledge, contacts, and crucially, leverage. So the attorney isn't just stamping papers like a notary.
Not at all.
They're the legal linchpin of that whole network.
Precisely. That's the idea. And our goal today, really, is to give you the tools to assess the complexity, the risk factors in your own specific transaction.
Right.
By the end of this deep dive, you should feel equipped to make an informed decision about whether investing in that legal representation makes sense for you, understanding that the attorney's value, well, it goes up exponentially as the deal gets more complex, moving beyond those standard low-risk situations.
Okay, let's dive into that. Section 1. The lawyer's role versus the title company. Let's start with what most people experience. The standard transaction model across the vast majority of the U.S.
Right.
You buy a house in, 80, 90% of states? The standard way is you set up an escrow account with a title insurance company, and they handle pretty much all the transaction paperwork.
That's absolutely the standard playbook. In the great majority of states, you have experienced people, escrow officers, closers at the title company who efficiently handled the documents, the money changing hands, processing the sale.
And it works, right?
Yeah. And we have to acknowledge, for basic low-risk deals, conventional financing, this approach has worked successfully countless times, even for seasoned investors. The title company is often very good at executing a standard routine transaction.
Okay, so here comes the critical question, the one the cost-conscious listener is definitely asking. If the title company is already guaranteeing the title, and they're giving me insurance against future financial loss if there is a title defect, why should I pay an attorney to basically do the same title search and review process all over again?
That is a fantastic challenge, and it really highlights the key difference. It's about loyalty and scope. A title company's loyalty, when you boil it down, is to the transaction itself and to the policy they're issuing.
Okay.
Their main goal is ensuring they can issue that policy without taking on undue liability themselves. An attorney's loyalty, it's 100% to you, the client.
Okay. So it's not duplicating the effort.
Not duplicating, no. It's providing an independent, exhaustive legal audit. They aren't just trying to issue a policy, they're trying to protect your interests completely.
How does that audit actually differ in practice then? What are they looking for that the title company might not be?
Think about the scope. The title company is generally very good at spotting recorded items, liens, mortgages, judgments that are clearly filed in the public record. Standard stuff.
Right.
But the attorney is trained to look for legal ambiguities or unperfected interests that might not be obvious just from the standard search affidavit provided by the seller or a quick records check.
Like what, for example?
Well, things like unreleased mortgages that were technically paid off years ago but never legally discharged in the records. That can cloud a title. Or boundary disputes may be stemming from vague old deeds, or even unaddressed mechanics liens from recent construction work. Maybe the contractor hasn't filed the lien yet, but they still have the right to.
Ah, things lurking beneath the surface.
Exactly. The attorney isn't just checking boxes on a form. They're actively thinking, how could this deal potentially fall apart in court? That's usually beyond the scope of a standard title search done quickly to meet a closing deadline.
And we should definitely mention the exception to this standard model, those states where having a lawyer involved is pretty much the default.
Yes, absolutely. There are a handful of states, mostly concentrated in the Northeast, where it's just standard practice for lawyers to be involved in almost all property purchases. Doesn't matter if it's simple or complex or if there's special financing, it's just how it's done there.
And what does that tell us?
Well, this regional difference kind of reinforces the idea that in certain markets, the inherent risk in transferring property is just seen as higher. So having independent legal counsel involved is considered almost like standard consumer protection. It goes beyond just the mechanics the title company handles.
Okay, so we've established the attorney sells their time and knowledge for legal soundness, whereas the agent is focused on the sale. Let's circle back to that idea of the work network. What exactly are we paying for when we bring an attorney into this network?
You're paying for highly differentiated intellectual assets. It's not just document review. The sources list things like advice, guidance, wisdom, information, instruction, intelligence, knowledge.
Okay, that's a long list.
It is, but also mentoring, strategy, counsel, contacts, connections, leads, leadership, leverage, and even just the legal labor itself. Let's try to make that a bit more concrete.
Please do.
Okay, so when you hire an attorney, you're paying for their wisdom on how, say, specific court rulings in your state might impact a clause in your purchase agreement. You're getting their strategy on the best way to structure a complex deal, maybe to maximize tax advantages or minimize your personal liability. You're using their leverage. The other side knows that if things go sideways in negotiation, your attorney is ready and able to take it to court.
That's a powerful position.
It is, and you're tapping into their contacts. Maybe they know specialized surveyors, environmental experts, or other professionals they trust implicitly. This goes way, way beyond just looking over the closing statement. It's about proactively setting up your investment for maximum protection against future legal challenges.
That makes a lot of sense, and it leads perfectly into the next section. The attorney's role in the transaction isn't standard. Our sources really hammer home that legal counsel is absolutely critical when you're dealing with things like seller financing or contractual agreements that don't get recorded publicly right away. The classic example here is the contract for deed.
Yeah, sometimes called a land contract. And this is where I'd argue the attorney shifts from being merely helpful to truly indispensable.
Why is that?
Well, with a contract for deed, you, the buyer or investor, you start making payments directly to the seller. But the actual deed, the legal title, isn't transferred or recorded in your name immediately. The seller officially still holds title. This lack of public record means there's no constructive notice to the world that you, the buyer, have an interest, an equitable claim on that property.
Okay, constructive notice. Let's break that down because you said that's key to understanding the, well, potentially catastrophic risk here. What does that mean legally?
Constructive notice is basically a legal fiction. It means that if a document, like a deed or a mortgage, is properly recorded in the Public Land Records Office.
Like the county recorder's office.
Exactly. Then the law presumes that everyone knows about it, or at least that they could have known about it if they'd bothered to look. It doesn't matter if they actually check the records or not.
Got it. So if your contract for deed isn't recorded,
then you have actual notice. I mean, you know about the contract because you signed it, but the rest of the world, banks, the sellers, creditors, the IRS, they don't have that constructive notice. Legally, they're unaware of your claim.
So paint the picture. What's the worst case scenario if that contract stays unrecorded?
Oh, it's severe. Because the seller still holds the public legal title, they could potentially either deliberately or just through bad luck mess things up badly for the buyer. They could take out new mortgages on the property using it as collateral. They could have other liens placed against it.
Yikes.
But the real potential disaster often comes from third parties. Imagine the seller has personal judgment creditors, people they owe money to from completely unrelated things. Or perhaps the most frightening possibility, the Internal Revenue Service.
The IRS.
Yes. If the IRS determines the seller owes significant back taxes and they slap a federal tax lien on that property because your buyer's interest, your equitable title under the contract, was never recorded. The IRS's lien often takes priority. It jumps ahead of your claim.
So wait, You could be diligently making payments for years,
Years, building equity.
only to find out when it's time for the seller to finally give you the deed that they actually can't deliver good title
Right.
because some prior, unknown to you but recorded claim like that legally outranks your unrecorded contract.
That's the nightmare scenario. Exactly. So the attorney's job here, number one, is to ensure the seller can legally deliver good title when the time comes. But just as importantly, they need to establish legal security for all the payments you've already made.
How do they do that?
Usually by making sure that the contract itself, or at least a summary document called a memorandum of contract, is properly recorded in the public records right at the beginning. That provides the constructive notice.
Ah, so it puts the world on notice about your claim.
Precisely. They're not just checking the title as it exists today. They're structuring the deal and recording the necessary documents to shield your payments and your future ownership rights against these potentially catastrophic external threats. That's a massive difference from just handling the paperwork for a standard closing.
Absolutely. Huge difference. Okay, let's pivot slightly now to contractual documents, moving beyond title itself. Let's talk leases. Our sources are really emphatic that real estate forms, especially rental and lease agreements, have to be properly crafted, not just to attract good tenants, but primarily to protect the owner legally.
Yes, and this is such a common pitfall, especially for newer investors. It's so easy to just grab a generic lease form from the internet or an office supply store. It looks official, has lots of legal-sounding language.
Seems fine. Right.
Seems fine, but it carries immense risk. Why? Because state laws vary. They vary wildly, not just on things like required disclosures, but on really specific legal definitions, mandatory grace periods for rent, security deposit rules, eviction procedures, and crucially, the actual enforceability of various clauses.
So something that looks standard might not even be legal in your state.
Exactly. The crucial warning from the sources is that certain provisions you find in generic sample forms might be completely unenforceable in your specific state or city because they conflict with local landlord-tenant statutes or established court precedents. Using a bad clause could get your whole lease challenged, or worse, get you penalized.
Which means consulting a licensed attorney in that specific area is really non-negotiable before you have anyone sign a lease or make any contractual commitment.
Absolutely non-negotiable for serious investors.
What are some of those specific lease details the sources highlighted as needing absolute legal precision?
Okay, several key elements came up repeatedly. First, the identification of residents. It needs to be precise. You have to properly name all individuals who are permitted to live in the unit, and that includes children, often for occupancy limit and legal liability reasons.
Makes sense. What else?
Second, all adult residents, everyone over 18 living there, must be required to sign the lease agreement.
Why is that so important? If one adult signs for the household,
Because if only one adult signs, the other adult occupants might not be legally bound by the terms of the contract. They could potentially claim squatters' rights in some situations, or it just makes eviction proceedings incredibly messy and complicated because you don't have a direct contractual relationship with them.
got it. Okay, what about managing the tenancy over time? Like, if a tenant wants to bring in a roommate or swap someone out.
That's the third critical area the sources mentioned. You need crystal clear, legally sound policies baked into the lease about bringing in additional or substitute tenants.
So, no informal agreements.
Definitely not. Most experienced landlords prohibit tenants from unilaterally swapping co-tenants or subletting any part of the premises without the landlord's explicit written permission. And that permission should always be contingent on a mandatory application and screening process for the new person.
And it's why so strict.
If you don't control this tightly through the lease language, you risk ending up with unscreened, potentially problematic occupants in your property. That compromises not just your security, but potentially the value of your asset and your relationship with other tenants if it's a multi-unit building.
Right. Okay, one more common issue. Disputes over landlord access. How does the attorney ensure the landlord's right to enter the property is legally protected, but also fair to the tenant?
Landlord access rights are absolutely paramount, but they have to be handled carefully and strictly comply with state-specific notice requirements. You can't just barge in.
What needs to be in the lease then?
The lease needs to establish very clear rights for the landlord to access the property for things like routine inspections, making necessary repairs, or showing the property to prospective new renters or even buyers if you decide to sell.
And the notice part?
Crucially, it must specify the amount of notice required by your state law. Often it's 24 or 48 hours written notice for non-emergency entry. And it also needs to clearly outline the exceptions, like immediate access for genuine emergencies that threaten life or property, like a fire or major flood.
So if the language isn't precise and state compliant.
Then a tenant can legally and easily deny you entry. That could delay critical repairs, leading to more damage, or prevent necessary inspections. It can expose the landlord to increased liability or property damage. The attorney's job is to make sure that access clause language is precise, compliant, and will hold up if the tenant ever tries to challenge it legally.
Okay, that's clear. Let's shift gears now in Section 3 to the investor's longer-term operational structure and risk mitigation. Many serious investors, as we know, use legal entities, LLCs, maybe corporations, to hold their real estate.
Yes, very common and generally advisable for liability protection.
But the sources are incredibly strict on this point. If you do use a legal entity like an LLC, you absolutely must maintain a 100% separation between your personal finances and the business's finances.
This isn't just, good bookkeeping advice. It is the fundamental legal requirement for actually maintaining the liability protection that you paid the attorney and the state filing fees to set up in the first place.
Explain that. Why is it so fundamental?
Okay, so you set up a limited liability company, an LLC. The whole point was to create a barrier, a legal wall, between the financial liabilities of the business, let's say a slip and fall lawsuit from a tenant, and your personal wealth, your personal savings, your family home, your car, etc.
Right. That barrier is often called the corporate veil, isn't it?
Yeah.
Can you maybe explain that concept and what piercing it means for listeners who aren't familiar?
Sure. The corporate veil is that legal shield, that separation between the owner's personal assets and the business's debts and liabilities. It's the primary benefit of forming the LLC or corporation. However, if the investor starts treating the LLC like their personal piggy bank, maybe they use the LLC debit card for groceries, or they pay their personal mortgage bill directly from the LLC checking account.
That's bad.
That's called commingling funds. And from a legal perspective, commingling is a terrible, terrible idea. Why? Because it essentially signals to a court, look, the owner doesn't even treat this business as a separate entity themselves. They treat it as an extension of their personal life.
And if a court agrees with that assessment, especially if the business gets sued.
Well, if the business is sued, the plaintiff's attorney is absolutely going to argue that the LLC isn't a real separate entity. They'll claim it's just a sham, a legal fiction, or what's called an alter ego of the owner.
And if the judge agrees.
If the court agrees that the separation wasn't maintained, they can pierce the corporate veil. That effectively dissolves the liability shield for that specific lawsuit. It means the plaintiff can then go after the investor's personal assets, savings, house, everything to satisfy the business debt or judgment.
Wow. So setting up the LLC is just the first step.
Exactly. The attorney helps set up the structure correctly, but then the investor has to commit to maintaining those strict operational habits, like never commingling funds, holding required annual meetings, even if it's just you, keeping separate books and records to keep that protective veil intact for the long haul. It requires discipline.
So that habit of strict separation is the long-term legal risk mitigation strategy. And that brings us nicely to another area of risk, taxes. Tax decisions in real estate, as the sources point out, are inherently complex and go way beyond just filing your 1040 each year.
Oh, absolutely. Think about just calculating the taxable income from a single rental property.
Yeah.
You start with your net operating income, NOI, your rent, minus your operating expenses.
Right.
But then you subtract critical deductions like the interest paid on your mortgage. And most importantly for many investors, you subtract depreciation.
Depreciation is key, isn't it? Even though it's not cash out of pocket.
It's huge. Depreciation is a non-cash expense that the IRS allows you to deduct, representing the theoretical wear and tear on the building over time. It's often this depreciation deduction that allows successful real estate investors to show positive cash flow month to month, yet report minimal or sometimes even negative taxable income on that property to the IRS. It's a complex calculation, and getting it wrong can be costly.
And this complexity is exactly why proactive tax planning, often involving a CPA or maybe an attorney with specific tax expertise, has to happen before you make major buy or sell decisions, not just when you're scrambling to file in April.
Precisely. You need that foresight. Sophisticated investors are constantly thinking about the tax implications. For instance, maybe they're planning a 1031 exchange.
The like-kind exchange.
Right, which allows them to sell an investment property and defer paying capital gains taxes. If they follow very strict rules about rolling those proceeds into a similar like-kind property within tight IRS deadlines, miss a deadline by a day, the whole tax deferral can be blown.
Or another popular strategy mentioned, the BRRRR method.
Yes, buy, rehab, rent, refinance, repeat. That's popular because the refinance step often allows investors to pull cash back out of the property. And frequently, that cash-out refinance money comes out tax-free as it's considered loan proceeds, not income.
But these aren't simple strategies.
Not at all. You cannot safely or effectively engage in strategies like 1031 exchanges or BRRR without careful upfront legal and tax counsel. The rules, the documentation requirements, the deadlines, they are incredibly strict and unforgiving. Mistakes are expensive.
That complexity really underscores the need for diligence, doesn't it? Especially when we consider how the IRS operates. Our sources brought up this concept, almost a mindset of guilty until proven innocent when discussing tax compliance. What do they mean by that?
Yeah, it's a powerful metaphor, and it really highlights the power dynamic involved with the IRS. Now, technically, in the U.S. tax system, the burden of proof is usually on the IRS to show you owe more tax. But practically speaking, the IRS has never publicly released its exact formula for deciding who gets audited. It's a bit of a black box. However, perception often becomes reality in this area. If a taxpayer is audited and the IRS finds significant discrepancies, let's say they find you improperly claimed a bunch of personal expenses as business deductions on your Schedule C or for your rental property.
Okay.
The chances of you being audited again in subsequent years go up dramatically. You essentially get flagged in their system. So while you might not be legally guilty until proven innocent, the practical consequence of getting things wrong is often increased scrutiny and a much higher compliance burden going forward.
Which is why that proactive legal and tax diligence is so critical.
Exactly. It's why savvy, wealthy investors typically keep their tax advisor on speed dial. They don't make major investment moves without running it by them first, because they know that defending yourself against an IRS challenge, even if it turns out to be an honest mistake on your part, is incredibly costly in terms of time, stress, and professional fees. Diligence up front saves massive headaches later.
Makes perfect sense. Okay, finally, let's touch on documentation as a legal shield, specifically thinking about the high-interaction world of short-term rentals, STRs, where communication with guests is constant.
Yes, this is a very modern challenge, amplified by platforms like Airbnb and VRBO. In the STR world, you have frequent guest interactions, questions before booking, check-in instructions, maybe issues during the stay, check-out messages. Every single one of those conversations is potentially a piece of evidence if a dispute arises.
So the advice from the sources.
The advice was crystal clear. Document everything. And, ideally, keep all communications strictly within the official messaging system of the booking platform itself.
Why is sticking to the platform's messenger so crucial? I mean, what's the harm if I just call a guest quickly to tell them where the spare key is hidden or shoot them a text about a minor maintenance issue? Seems faster sometimes.
It might seem faster, but here's the risk. If you use external communication channels, phone calls, which usually aren't recorded, text messages, personal email, and then a dispute comes up later. Maybe it's about property damage the guest denies causing, or a disagreement over cancellation terms, or a claim against their security deposit.
Yeah.
It very quickly devolves into a he said, she said situation. There's no easily verifiable, time-stamped, objective record of those external conversations that the booking platform can rely on. Who actually said what, when? It becomes legally ambiguous.
And when the platform, acting as the arbitrator, faces that kind of ambiguity.
Historically, and according to the sources we looked at, the platform is often highly likely to side with the guest in ambiguous situations. They tend to prioritize the guest experience. So forcing yourself and the guest to document everything within the platform's own verifiable messaging system where all the records are timestamped, archived, and accessible to the platform's resolution team is really a proactive legal protection measure. It's designed specifically to eliminate that ambiguity.
Can you give an example?
Sure. Imagine a guest checks out and later claims via text message that the sofa was already damaged when they arrived. But if the host has messages within the platform's app from check-in day, where the guest confirmed everything looked great, or maybe even sent pictures showing the undamaged sofa.
Then the host has clear proof.
Exactly. An attorney defending the host in that dispute would use that clear, platform-documented communication history to easily disprove the guest's later undocumented claim. It's a habit, a discipline, that translates directly into stronger legal footing when, inevitably, disputes arise in the STR business.
That's a really practical takeaway. Okay, this has been a truly comprehensive breakdown, I think, really separating the attorney's value proposition from the title company and the real estate agent. Let's try to recap the main points.
Sounds good.
While the day-to-day transactional paperwork for standard, simple deals might be safely delegated to experienced title or escrow personnel in many places. The attorney's primary, unique function is really managing the legal risk, the kind of risk that most investors, frankly, aren't equipped to even identify, let alone mitigate.
Right.
This includes digging deep to ensure good title, especially against those scary priority claims we discussed with unrecorded contracts. It includes crafting legally sound, enforceable contracts like leases that will actually stand up in court against challenges based on specific state laws. And it includes setting up and helping maintain the structural integrity of your liability protection, like your LLC, by advising on things like avoiding commingling.
That assurance and protection, that's really the core deliverable you're paying for. Real estate isn't just a simple business transaction. It operates within a highly regulated system that is constantly shaped by and dependent on decades, even centuries, of court rulings and legal precedents. The attorney's job is to navigate that complex, precedent-driven system to ensure it works to protect your specific interests. This becomes especially crucial in novel or non-standard situations, whether you're facing title complexities with seller financing or you're trying to navigate the highly technical requirements of advanced tax strategies like 1031 exchanges. They provide the legal wisdom, the specialized knowledge, and often the critical connections that form the lifelines of any serious investor's work network.
We've really established how integral the attorney is to understanding and navigating that existing legal framework. And our sources highlighted a fundamental truth about U.S. property law, that land use regulation is heavily dependent on court rulings and operates under some pretty tight constitutional limits, historically designed to prevent excessive public infringement on private property rights.
Which brings us perfectly to our final provocative thought for you, the listener, to maybe explore on your own.
Okay, let's hear it.
If those bedrock constitutional limits that guide property law were to be continually tested, perhaps even stressed, by rapidly evolving new technologies, think about things like fintech-enabled smart contracts that could theoretically execute a real estate closing automatically based on predefined conditions, or maybe automated escrow services powered by AI.
Wow, okay. Where are you going with this?
Well, how quickly might the legal landscape around property rights have to change or adapt? These technologies might remove some of the human intermediaries, the escrow officer, maybe even aspects of the agent's role, but they don't remove the underlying legal risk.
If anything, they might introduce new risks we haven't even thought of yet.
Exactly. This could be the new frontier, a place where having ongoing, proactive legal counsel isn't just about mitigating the risks we already know from history, but about strategically positioning yourself at the forefront of the future of property ownership. It's about ensuring your rights are protected even when the process of buying and selling real estate becomes increasingly automated and technologically driven. That's where the value of forward-thinking legal advice might become truly indispensable.